Welcome back, Professor Jocelyn Hardrick, Criminal Law, Week 4. We're going to be wrapping up homicide. We're also going to be talking about a sensitive subject, sexual offenses. Because of that, I won't be calling on students during the live portion. I will let you volunteer. We will talk about some of the technicalities of the laws behind sexual offenses under common law, modern penal code, and under Florida statutes. And then we will also be watching some videos that talks about how sexual offenses are treated now versus how it used to be treated. And so if for any reason you find some of these issues are triggering for you, you can kind of fast forward. And I will, when I show you the clips from the videos, there will be, you'll have access to it. I will describe what's in it so you'll know whether or not it's something you'll feel comfortable watching. So here we go. We're going to review again, as we always do. It's really important every week that you review what we've covered previously and then tie it to the new material we're learning now. This is cumulative. We are building this idea of what is this body of law called criminal law, how does it all fit together? And so make sure you review on your own, and we will continue to review the prior weeks. Every week we cover a new topic. So we know evidence, direct or circumstantial, both are admissible. We know there's these two major theories of punishment, retributivism and utilitarianism. Retributivism involves an eye for an eye. You do more wrong, you must pay. And utilitarianism is about the greatest good for the greatest amount of people. And you're looking for things like general deterrence, specific deterrence, and rehabilitation. Also, corpus delicti, when it comes to homicide, needs death and criminal agency, but it's typically already covered. But it is a prerequisite, and so if a defendant challenges it, then the prosecutor is going to have to go ahead and establish it. And so the larger picture we're all moving towards is the guilty hand moved by the guilty mind under the required circumstances that sometimes cause a bad result in the absence of a justification or excuse. So today we're looking at the guilty hand and the guilty mind surrounding sexual assault. In week 2, we learned about common law rules for murder and manslaughter. And we know that murder requires the killing of a human being by another human being with malice aforethought. And so under murder, we have the 4 kinds of malice aforethought that were recognized under the common law: intent to kill, intent to do great bodily harm, depraved heart, and felony murder. We also went a little more into what felony murder looks like and the limitations attached to it, because it is the easiest form of murder to prove. And then we have voluntary manslaughter, which is a mitigation, meaning because of specific circumstances, the law is willing to sentence you less harshly. Those circumstances are a heat of passion. There was some kind of legally adequate provocation that got you into that heat of passion, and you did not have time to cool off. And so this just recognizes the human frailties of getting really upset in the moment and doing what's called, losing your mind or forgetting yourself for a minute. And we have involuntary manslaughter when we have actions that rise to the level of criminal negligence. So acting outside of the reasonable care given to a reasonable person, and you should have been aware of the risk involved, and you still took the actions, even if you weren't aware in that moment for various reasons. So we covered those, why they had criminal negligence and involuntary manslaughter. When we go to the modern times, you'll see they have other ways to handle those kinds of acts. So we covered that in week 3. We have the statutory model, which is a degrees model of murder. Okay, it's a model. So generally speaking, for our purposes, this is what we're going to look at if I say the jurisdiction is using a degrees model or statutory model. Otherwise, you will actually receive a statute which you will interpret and use to do your analysis. And so we know murder in first degree usually involves willful, deliberate, and premeditated. You need all 3 in order for it to be considered first degree murder. But if you have intent to kill without willfulness, deliberation, and premeditation, and the other forms of murder recognized at common law, you're in murder in the second degree. And then capital murder we touched on because Florida is a capital murder state. It does have the death penalty. Usually you'll see it's involved when there's some kind of aggravation, and it results in a punishment of the death penalty. So they really want it to be for the most harsh crimes. Historically speaking, I mean, even sexual assault used to be a capital crime here in Florida and other states. That has since gone away, and there's a lot of rules about when you can find that someone's crime satisfies what's required for a capital punishment. And there's a lot of safeguards put in place before the person can be sentenced and then have it executed. You're going to find out more about that in criminal procedure, or if you study a Florida-specific course, they'll go into that as well. Under the Model Penal Code, we have murder being defined as purposely or knowingly or recklessly plus, and the plus is basically with extreme indifference to human life. That's what the plus is. But if you're just acting recklessly, meaning you have a conscious disregard of a very high risk of harm or death to others, then you will be charged with manslaughter. And then if you have an extreme mental or emotional disturbance with a reasonable explanation for it, you may also be able to mitigate a murder to manslaughter. Okay, so whenever we're mitigating in homicide, going from murder to manslaughter, always remember there's an act that would otherwise constitute murder, an intent to kill. But because of heat of passion provocation and no cooling off period, or EMED, the law is willing to reduce the charge to manslaughter, which will come with a less severe punishment. And the Model Penal Code does kind of have its own version of involuntary manslaughter, except it calls it negligent homicide, and there you'll see criminal negligence, and you are compared to the reasonable person when you're looking at a negligent homicide claim. So here's the hypothetical I want you to consider, and when we get to the live portion of the class, I will ask for volunteers regarding this particular hypothetical to kind of analyze what you think is going on here, based on what we've studied about homicide so far. So, Ryder, who is the defendant, intended to kill RP Talent, whom defendant suspected of having an affair with his wife. Armed with a shotgun, defendant walked to Talent's house in search of his wife. Near the house, Talent approached defendant with an axe, intending to strike him. After defendant told Talent to stop, defendant shot and killed him. Defendant was charged with first-degree murder. At trial, the court instructed the jury that defendant was guilty if they believed that defendant went to Talent's home with the intention of killing him, and that he armed himself with a gun, and thereafter went in search of Talent and did, in fact, shoot and kill Talent. Defendant was convicted and he appealed. So what do you think happens here? It seems like we have the mens rea is met for murder, and we have the actus reus, right? He intended to kill him, and then he actually did shoot him and kill him. So what will be the basis of the appeal? And what do you think the court would say? And to give you a little clue here, this is something that we're looking at in terms of concurrence. When we have a mens rea and an actus reus, we need them to be occurring at the same time. And so now that I've given you that clue, think about whether that's what happened here, and we'll discuss it later. So here's a homicide definitions exercise. This is a great way for you to practice internalizing this information and making sure that you can put it in your own words. So you'll find this on the page where you get more information for the class for the week 4 module. Go through each one of these and see if you can, off the top of your head, without referring to your notes, write out the definitions for each of these different concepts. And then go back and see what you missed, and you know what you need to focus on this week in your study session. Okay, so this is just the homicide definitions. Very low on Bloom's taxonomy. We're literally at the bottom where I'm just asking you to recognize what it is. And so you just need to be able to articulate it. It doesn't have to be perfect, right? But it should cover all the bases when it comes to the definition. And they're pretty easy to memorize. You say them to yourself a few times, you look at flashcards, you talk to your study group with it, and you write it out a couple of times, and you'll be able to articulate it pretty quickly. Okay, so that is a nice strong foundation. Make sure you have all of those definitions memorized so that we can move up Bloom's taxonomy as we go on in class. Here's another exercise. So this is a problem-solving exercise on felony murder. This is something that we're going to do throughout the term. You're going to look at a certain scenario, and I'm going to tell you a rule or part of a rule that we're exploring. And I want you to tell me if the scenario you read is an example of that rule or a non-example, meaning it does not fit that rule. The great thing about doing this kind of exercise is this is how you issue spot on an essay or on a multiple choice question, but that has those long paragraphs, right? Those multi-state bar examination style multiple choice questions. When you read the facts, you'll recognize what rule you think is being tested, then you'll be able to say, oh, this meets the rule. So I know my answer, I'm looking for an answer that says the rule is met, or it does not meet the rule, and here's why. And then you're looking for that in the answer choices as well. So read the following example and non-example of an unknown new rule, one that the judges writing their opinions and orders have not expressly stated, but that you must instead discern and record as your problem solution. So vocalize each mental operation taken toward a partial solution until you reach and record the final novel rule. Check your answer against the model answer, and I'm going to tell you what the model answer is during our live class. So here is the first example of the rule. So the judge writes opinion and order, in this case alleging felony murder. The prosecution has shown evidence at preliminary examination that defendant and another suspect, whom authorities have not arrested, robbed the bank using no weapons. Police gave chase in a squad car, and defendant's flight from the scene on motorcycle, but police struck and killed a pedestrian during and as a result of defendant's flight. Defendant, through assigned counsel, has moved to dismiss. The court grants the defendant's motion dismissing the charge. So this is an example of that court applying a rule. And what I'm trying to get you to do here is identify the rule that the court is applying. So this next one is an example that's outside of the rule. The court is not applying the rule here. And so you kind of have to look at, develop the rule from the first one, then apply it to the facts in the second one to see if it still meets the rule. In this case, alleging felony murder, the prosecution has shown evidence at preliminary examination that defendant and another suspect, whom authorities have not identified and arrested, committed a sexual assault in an urban park. After the attack was complete, the victim called 911, resulting in a police chase at a vehicle driven by the other suspect, while defendant attempted escape on foot. The other suspect struck and killed a pedestrian in the course of the flight. Defendant has moved to dismiss. The court denies defendant's motion, setting the charge for jury trial. So, look at the first part and the second part. In the first one, you see that the police struck and killed a pedestrian. In the second one, you see one of the suspects struck and killed a pedestrian. Both involve car chases, but that's the main difference. Both involve some type of crime being committed and an escape while police officers were in pursuit. And so think about the felony murder limitations we discussed last week and see if you can identify the rule that's being discussed here. So this is a higher level exercise on Bloom's taxonomy than the definitions worksheet. And so you have to realize you have to do both kinds of exercises. Sometimes you have to do the easy stuff, which is just articulating and recognizing, right? Rewriting things in your own words, trying to remember the definitions. And other times you need a new set of facts and you have to kind of assess, analyze, create, so that you can be higher on Bloom's taxonomy, which assumes that you understand the underlying information, which here is how felony murder works and what its limitations are. So I will call on students regarding this particular exercise to hear what you came up with. So let's go back real quick. There's a homicide worksheet, example, non-example. I'm going to ask you to do that as well as part of the recorded lecture and pre-lecture series. Go through that, take a look at what you think are, that's the one where you get the rule and you get some fact patterns and you're asked, is it an example of the rule or non-example? That really helps you to understand how the rule works. Okay, we'll go over that in class as well. So now we're into week 4, where we're going to talk about sexual assault. For the purposes of this lecture and the live class, I won't go too much into calling on individual students, but the students who have signed up for week 4 clerkship group are going to be speaking about this topic. They're going to be going through the cases that we covered, and they will be doing the hypothetical question and walking us through that analysis so that we understand how to apply these rules to a set of facts. So one thing you need to know now is sexual assault is now called sexual assault. It used to be rape under common law, and it was very, very specific and narrow, and frankly was a really hard crime to prove. And so now the trend is to treat rape and all other forms of sexual assault as sexual violence. And it's a violent act against a person, so it's to be treated like other violent acts like assault and battery, robbery, and attempted murder and things like that. And so in your week 4 module, you will find this video. It is a video advocating for the stop of sexual violence. It has some information about statistics and things you can do to protect yourself and others. One of the other trends is going from protecting people, particularly women and children, from rape, to getting everyone involved and saying this is an activity that society finds unacceptable. Not only should people have to protect themselves against it, but we should be advocating for people to stop doing the act and recognizing what the act is and how it can violate somebody's rights, safety, personal space, and how it is a violent act against individuals. So take a look at that video. It's only a couple of minutes. And here is the common law definition. Let's take a look at it. So under common law, rape is defined as sexual intercourse by a man with a woman, not his wife. The man uses or threatens physical force, and the woman does not consent. Let that sink in. So at common law, there was no crime of rape if the victim was the man's wife. Further, only a woman could bring a charge, not a charge, but can accuse a man of rape. There was no recognition of same-sex sexual violence as a crime. There was a recognition of same-sex intercourse or sexual contact as a crime. Some of those are still on the books, but they're not enforced anymore. And obviously, since the Supreme Court has held that people of the same sex can legally get married and it must be recognized by all the states and the federal government, those laws are now obsolete. But that's how that was addressed. But you're not able to bring the crime of rape if you're the person who attacked you was of the same sex. And then also here you see the man uses or threatens physical force. And so you can't have things like extortion, right? There has to be a use of force or physical force. It doesn't say psychological force, blackmail, things like that. And then you see this idea of the woman does not consent. What does that really mean? We're going to explore consent a little more, particularly in modern times. But during common law times, they required that a woman physically resist, and that is how she had to show a lack of consent. So even though it's not listed here as an element, just understand the lack of consent had to be demonstrated with resistance, physical resistance, fighting off. If you just laid there and allowed the act to happen, that would not be considered rape, or you would not be able to sustain a charge of rape, because the theory was we have to protect women and their chastity, and a chaste woman who really doesn't want to have sex will physically resist. Well, obviously even then it wasn't true. To this day it's not true, because if you're being threatened with violence, or violence is being used against you, you may decide it's safer for you not to fight back, because then there will be an increased amount of violence in addition to the sexual act. And also here you see sexual intercourse, so it's only a very narrow definition of sexual acts. We know there's more than that involved in sexual acts, and there's other kinds of sexual contact, but if it was not intercourse, it would not be rape under common law. So as you can see, very narrow definition, very difficult for a woman to prove, and thank goodness they've transitioned to something that's much more inclusive and can protect more people. So now we have modern statutes. Let's take a look at them. They, generally speaking, renamed rape to sexual assault or battery or criminal sexual conduct. They involve all forms of forcible sex. They are generally gender neutral, so same gender sex is included. So a man can also be a victim, and the victim can accuse someone of the same gender of sexual violence or assault or battery. Sexual contact is included, so you don't have to have penetration, but there may be like lesser included offenses if you use different things for penetration, or if you just make contact with the other person's body. And it's a move towards treating rape and sexual crimes as violent criminal acts, no matter the specific quality of the victim, gender, age, etc. So that is the trend in modern statutes. The MPC defines sexual assault in this way. So it gives a mens rea of knowingly or recklessly. You see it says he or she. This one is specifically second-degree rape. And it requires the use of physical force or restraint or implied or expressed threat of force, bodily injury, restraint, and it causes the other person to engage in an act of sexual intercourse with anyone, not just the individual threatening them, as you can see, so much broader. And then also if it causes another person to engage in an act of sexual intercourse by threatening to inflict bodily injury on someone other than the person, right? So you'll see that a lot with individuals threatening someone's child or children or a parent or some other vulnerable person. And so much broader definition. Here you see it's continued. They also talk about has or enables another person to have sexual intercourse. And you see it's sleeping, unconscious, physically unable to express non-consent. So now we're solving this issue regarding what does consent look like. If someone is unable to express consent, that's going to automatically be considered a lack of consent. Under common law, that's not quite how it worked. And so you're covering a lot of information, and you see here, we're going to talk about statutory rape, and that is when it's rape by law, meaning if a person's under a certain age or the two individuals do not meet certain age requirements, then by law it will be rape, whether or not the individuals consented. Here, Model Penal Code has 12 years old, but it also is covering this inability to consent and lacking substantial capacity. So sometimes you do have individuals who are adults, but they're under the influence of drugs or alcohol or intoxicating substances, or they may be mentally impaired in another way that takes away their ability to appraise or control their conduct. And I want to just take a little look at the MPC definitions. So they define consent, and they define it as positive agreement communicated by words or actions. Non-consent means a refusal to consent or by communicating words or actions. Verbally expressed refusal establishes non-consent in the absence of subsequent words or actions indicating positive agreement. So, sometimes you have people who are changing their minds or they're not saying much. And so it's trying to help fill those gaps and make the law clear so that people can conform their behavior to the law. Recklessly is defined here so that you know how you can recklessly engage in one of these acts. And then sexual contact includes sexual intercourse, which you see we're at 16, 17, 18, 19, 20. They really list out all the different ways an individual can engage in quote-unquote intercourse to make sure they're covering all the bases. So let's take a look now at Florida statutes, section 794.011, and see how it defines some of these terms. So here it says consent means intelligent, knowing, and voluntary consent, and it does not include coerced submission. So if they coerce it out of you, that does not count. And consent is also deemed construed to mean failure by the alleged victim to offer physical resistance to the offender. So Florida kind of adopted a little bit of that common law idea of physical resistance. Or it rejected it, I'm sorry. Consent shall not be deemed or construed to mean the failure to offer physical resistance. But that's a nod to the common law. They want to make it clear that they are not adopting that part of the common law. And as I told you, the age plays a role in this. So here you see they're talking about person 18 or older who commits sexual battery upon a person 18 or older without consent is one type of felony of 1 degree. Then you start going to second degree. Then you go into assault against minors, 12 or younger. They adopt the MPC age of 12. And as you can see, I'm showing you here, capital felony. If the person is 12 years younger who is the victim. And then they also talk about if the person who commits the act is less than 18 years of age, life felony. When we're involved with cases where minors are the victims. And common law presumption relating to age is abolished. Again, you see the Florida legislator making sure that they make it clear that these presumptions are not to be applied. So when judges and lawyers are researching this and trying to decide how to decide these several cases or how to argue them, they know that they cannot rely on these common law rules. And so if they're looking at a case that relied on common law rule, it's not going to be binding. And so the common law used to say that a boy under 14 years of age was conclusively presumed to be incapable of committing rape. 14. And we know at 14, young men have hit puberty and are able to commit the acts, but under common law, you could not charge him with rape. And now that has changed. And so that is why they have to kind of go through and break down the ages of the victims and the perpetrators when trying to figure out how to punish these crimes. Order also addresses this idea of lewd and lascivious behavior. You might have heard that term before. So it just goes into these ideas of sexual acts, particularly against minors, and Prohibited defenses, ignorance or belief of victim's age. So what that means is strict liability offense. Your knowledge of the person's age or your belief of the person being younger or lack of knowledge is not going to be a defense in any way. If that person is below the age and you commit those acts, then you can be found guilty of these crimes. So the Department of Justice, so that's on the federal level, has adopted a new definition of rape. So it shows before, forcible rape used to equal the carnal knowledge of a female forcibly and against her will. And it recognized that that definition had not changed since 1927 and saw it as outdated and narrow. The new definition under the Department of Justice is the penetration, no matter how slight, of the vagina or anus with any body part or object, or oral penetration by a sex organ of another person without the consent of the victim. So not nearly as broad as Model Penal Code, but definitely much broader than the common law definition. And here's the link where you can find that and more information, and I will include that link in your module. So what exactly is force for purposes of sexual assault? So you're going to hear this idea of force come up in other crimes and also in defenses. So you always have to make sure when you're analyzing force, you're looking at it in the context of the particular crime or defense. Here, force means, at a minimum, any amount of sexual touching brought about involuntarily, any minimal force which constitutes the unconsented to touching, including penetration, any degree of physical power or strength used against a victim, even if not leaving a marker and causing injury. So that has to be important. You don't have to cause injury. But if you're using force against the person, like pinning someone down, and it may hurt a little bit, but really it's not, once you release them, there's no long-lasting injury, that still counts. And but the force needed to go beyond mere penetration. If the only force that was involved was penetration, that was not enough. So you need to have some more. A woman pushing, the man holding down. It doesn't have to be all out kicking, screaming, scratching, but it also cannot just be the mere penetration. And so we're looking for something in between. And the physical force used to overcome the lack of consent. Okay, that can count as well. So let's take a look now at what's called statutory rape. I realize some students got confused with that. It's a term that's kind of misleading because it's called statutory rape in the sense that it's rape by law, not because of lack of consent, but there are also statutes defining rape and sexual assault. So common law did have statutory rape, meaning if the individual is below a certain age, consent did not play a role in it, and so it was automatically rape if there was sexual contact between that minor and someone else, an adult. And as you can see, 14 years old used to be the cutoff age for men to be considered perpetrators, that to be 15 and older. And so let's take a look at the common law and MPC. So intercourse by a male with a quote-unquote underage female to whom he is not married. The age of consent varied. It's typically 12 or younger, and also as young as 10. So if you look at Dressler and some other resources, they're going to say 10 years or younger. But sometimes it did vary. You know, common law involves the law from England and the United States and amongst the various states until they started to codify all those laws. And so that's why I said it varied, but I'm going to use 10 years or younger for common law. Under the MPC, section 213.1, you see they're using 12 years old as the cutoff age. Strict liability crime, it means you do not have to intend to have sex with a minor, and even if you don't know, you have no knowledge, or whether you knew or should have known, it doesn't matter. If you were an adult having sex with someone under the age of consent, you will be found guilty of statutory rape, even if that person consents. So that's what's important to know with statutory rape. And under Florida, here they have a very specific layout for that. The alleged perpetrator has to be 24 years of age or older, and engage in sexual activity with a person 16 or 17 years of age. So that's very specific. So this is not necessarily the kind where they're protecting minors who are 12 or younger. This is when we're talking about Romeo and Juliet kind of cases. And this is probably in response to the fact that, someone can be a senior in high school and be 18 or 19, and you have a young person who's a freshman who can be 13, 14, or 15 years old. And so if a senior is dating a freshman, that's a very common activity, and it's very common for those two to be engaged in sexual acts. And so they did not want that to be considered statutory rape and be punishable as harshly as these other sexual assault crimes, particularly now because there's all these registry requirements that you have to register as a sex offender, which can change your life for the worse indefinitely, if not permanently. And so now, in order to avoid that kind of problem, the requirement is that the person is 24 or older, and the alleged victim is 16 or 17. So now we have clearly someone who's an adult, 7 or 8 years older than the young person, and so they're being put on notice that this is not the kind of behavior to consider acceptable, and this would be statutory rape. Now let's explore what consent means. When does no mean no? Does the victim have to say the word no or yes out loud? This is one of the biggest challenges that prosecutors and defense attorneys and judges and legislatures have to deal with. How do we really define the confines of consent so that individuals who are not present during the act are trying to reconstruct it and decide at what point was consent given or not given, or it became clear that a lack of consent was being communicated? Very difficult to do. When it is, a random attack by a stranger and there's violence involved, those tend to be much more clear-cut cases about a lack of consent. And so as long as they prove that the defendant is the one who engaged in that act, those cases are easier to convict. But what if it's two people who are on a date? What happens then? Two people who are living in the same space, roommates or family members who are visiting, or other things like that. Someone who starts to engage in a sexual act but then changes his or her mind and no longer wants to. Someone who doesn't say anything. There's very little words exchanged. Actually, the act occurs, but there's no resistance, there's no lack of consent, there's no words of no or stop, but the person does not necessarily engage in it. We have to try to figure these things out after the fact. It's very difficult, and that is also why these cases can be very difficult, and why people who are victims of it don't come forward, because they don't want to have to deal with this and try to reconstruct these experiences. And so it makes it very difficult to prosecute, and also just very difficult for the alleged victim who is dealing with trauma to have to go through it again. But we're going to explore a little bit about that so that at least we know generally the kinds of things we're going to be looking for. So in this video here that you're going to see in the week 4 module, you have a victim that is in a jurisdiction. This is Law and Order SVU, so it's New York, but it's fictional jurisdiction. And I'm asking you to consider, should the law require that unless a victim clearly indicates consent by saying yes, then it can be rape? And so that puts people on notice. If you are in a situation where you're about to engage into a sexual act, you're going to have the person tell you yes. You can't just read body language and say, it seemed like he or she wanted it, which is what you hear a lot, basically, when it's depicted on TV or in college campuses all over the country, or in bars or what have you, where people are slightly intoxicated. What happens when you tell people they have to actually say yes? What does that do for sexual acts, and is that fair way to decide consent? California has passed an affirmative consent law, and so I'll have that link for you in the week 4 module. You can take a look at what that looks like. And so in this clip, that's something that's mentioned, that California had passed that law. And there's a little bit of discussion about whether or not that would help with prosecuting and would help reduce the crime of rape. This particular clip also involves two young people. They were both young, about the same age, I believe. And so you have them trying to figure out at what point was it clear that the alleged victim did not consent, so that the defendant being charged would know that he would have to stop or pull away. So take a look at that clip and the law, and just think about what you think is best regarding how to frame consent from the lawmaker's point of view. So gender norms, another food for thought. When we're learning these laws, we don't want to do them in a vacuum. We always want to do them in the context of real life experiences. And so I just want you to think about this. The gender of the defendant matter when it comes to whether or not there was consent. Does the gender of the victim matter? You know, our stereotypes regarding men, for example, that they tend to be more prone to violence, mean that they are more likely to commit the act. The studies show that they are the ones who are accused of committing the act, and when they look at who is actually who are the victims of it, even if they're not able to prosecute it later, it's typically women and children. And so what does that mean about how the laws are structured? Do gender norms play into whether or not a woman is consenting because of stereotypes about women either being more passive or supposed to be more passive and easygoing, or communicating differently than men do, and so a man is reading into her quote-unquote body language instead of what she's actually saying or doing. And then of course we have children being involved in how they're being raised to consider things like consent and whether or not they can touch other people in ways that the person being touched find inappropriate. How are we raising our children to understand these ideas of consent, if we are at all? I've read articles that say that we're raising children based on gender to show that it is okay to touch people without consent, and so when they become older, that's so ingrained in them, it becomes very difficult for them to understand that that is no longer okay. And it tends to fall along gender lines. And so these are all the kinds of things we have to think about when these cases are being prosecuted in criminal law, because at the end of the day, if it gets to a trial, it's typically a jury trying to figure these things out. And if we understand that these gender stereotypes and norms exist, then it's going to come out through the jury. And it's going to play a role in whether or not they find victims credible, other witnesses credible, the defendant's story credible, and ultimately deciding whether or not they find people guilty or not guilty. So this is a particular video that's in the module. I use it to discuss victim shaming. This video is much more intense because she is a young woman who's engaged, I think, in the sex video industry. And she is accused an individual of rape, and particularly using a lot of physical violence and force. In her work as an actress, she depicts violent sex acts. But in the videos, her argument is that's consensual and that is acting. In real life, I don't want to engage in that, and I made it clear to the defendant in the case. And so the defense attorney really just goes into her about it. And so this could be a video that's triggering for you. If it is, don't watch it. But if it's not, you can really take a look at it and I just want you to think about it. I'm not saying one answer is right or wrong, but you never know. You might end up on a jury one of these days for a case like this or similar to this. And I want you to have thought through what is the fairest way to deal with something like this for a very difficult situation, very difficult to prosecute, very difficult for victims, and for people accused of the crimes who feel like they weren't doing anything wrong and that there was consent and they were role playing, and so now they're being convicted of a crime when they thought they were engaged in a sexual act. And so, the victim should be treated fairly and given the opportunity to show their case and present evidence. But obviously, the accused also needs to have a way to properly defend him or herself. In the common law, there was a big concern about false accusations of rape. Whether or not it was actually a big problem, the law was set out to protect men against false accusations, which is why they had this requirement that the woman had to physically resist. But if you think about it, this can also be a way for particularly powerful men to get away with engaging in forcible sex acts on women who are vulnerable, like servants and children and people who were dependent on them one way or the other, or could end up in jail, or were poor, or other characteristics that made them vulnerable. And so it'll be very difficult for those individuals to then not only protect themselves against these acts, but then get justice for it. In the Me Too movement, you hear all these stories coming out, and a lot of times they involve people who are powerful, but not all the times. But it's typically someone who has some kind of control over the individual, who has more money, more access to lawyers and resources, and who society will generally consider more credible. And then so the victim now becomes attacked. And so it becomes very difficult for victims to come forward if they feel like they're going to be attacked. Everything in their history is going to come out. Every bad thing they ever did in their lives will now suddenly become subject to attack and view by society, by the defense attorney, and by the jury. And so that's kind of the sum total of victim shaming. Is a long history of it. And so there is some work to try to get away from that so that everyone can get a fair shot at a trial and all the evidence can come out and the jury can make a fair determination of what they believe happened. But this is like all the problems we have in criminal law. It's a work in progress. And the good thing is moving towards treating victims much more fairly, being more inclusive, and treating the sexual violence as violent acts against individuals that can be prosecuted just like other violent acts. So thank you for listening into this lecture. I will see you during the live portion of the class. We will go over the initial part, the review. I will be calling on students. Please make sure you watch the videos, the other videos before the live class if you're able to. Like I said, if not, that's fine. For the discussion part for the sexual assault crimes, we will go through the hypothetical. So you'll see how this is tested on an exam. And I will also go through the other cases that you had to brief for this week so we can see how courts have treated all these different issues that I brought up in this video. Thank you.